Hi, I'm Lone Candle. Republican senators ignored President Obama's Supreme Court nominee, Merrick Garland. Did they do so because he was corrupt? No. He has a clean ethics record. Did they do so because he had some sort of major conflict of interest? No. Did they do so because Merrick Garland is unqualified? He has excellent qualifications as a judge. Republican senators refused to even consider this man out of partisanship or/and ideology. Doing so goes against the Founding Fathers' intentions in the Appointment Clause, where it says that the President shall have the power to nominate and, by and with the advice and consent of the Senate, appoint judges of the Supreme Court. The intention was for this to be a presidential power mediated by the Senate for the case of unqualified or ethically problematic judges. The Republican senators are defying the Constitution's intention by both weakening the president's power to choose Supreme Court justices and by refusing consent based on the judge's judicial philosophy. While the case of Merrick Garland is blatant because the Republicans are pretending like the president's power only extends for 3 of his 4 years, which is ridiculous. This flagrant disregard for how our democracy was designed to operate is only one example of the Senate's behavior. Both Democratic and Republican senators have used their power of advice and consent to limit the president's choice based on ideology or/and partisanship. My point here is the hypocrisy of constitutional conservatives who claim that much of their politics is based on key principles that the government should act within the founders' intent for the Constitution. Such people decried half the things Obama did, and usually on weak constitutional grounds. But here, with Merrick Garland, we have a clear violation of the founders' intent. And all we hear is crickets. Chirp, chirp. Many politicians, pundits, and citizens constantly preach the founders' intentions when the government is doing something they don't like. If they are not making the same complaints now, then they are proven to be nothing but hypocrites. Woe to them, those snakes, those brood of vipers, puffing themselves up on their principles they think or pretend they believe. Woe to them who throw around the word tyranny like any disagreement on foggy constitutional issues means the official they disagree with is a tyrant. Woe to them who use the Constitution like a mere tool to oppose what they dislike, but then ignore it when the government violates the Constitution's intention to do what they like. Seriously, woe to them. Now, the Senate's actions are probably legally constitutional. I'm not claiming that rejecting or ignoring presidential Supreme Court nominees based on ideology is a clear violation of the words of the Constitution. But it's a violation of the intention. On accepting, rejecting, or ignoring nominees, the Senate can pretty much do whatever it wants. The Constitution gives no clear obligation that forces the Senate to act. The Senate gets to make its own rules on how it proceeds. Scattered throughout the history of our republic, the Senate has gone against the founders' intentions and refused nominees out of partisanship or ideology. So, if there are any comments to this video explaining how the Constitution doesn't legally force the Senate to act, or to not use ideology, or that the Senate has done this before, I don't know who they're responding to. But it's not what I'm saying in this video. I'm saying that the founders decided to give the power of appointing Supreme Court nominees to the President of the United States. And the Senate's job was to approve or disapprove based on basic appropriateness to the job. The Senate using the power to advance other agendas violates the intention of the Constitution and its founders. Now, let me tell you why this is the case. While there are many sources that could be used to make this argument, I think Joseph S. Larissa Jr. describes it best, and with a focus that's close to mine. So I'll mostly use his account in his 1989 article in the Boston College Law Review. As with all parts of the original Constitution, it was hammered out with many compromises in the Constitutional Convention of 1787. At first, James Madison preferred Senate appointment. He wanted judges chosen in a way that ensured, quote, judges of the requisite qualifications. While at the same time, he thought selection by a numerous body, like a legislator, could lead to, quote, danger of intrigue and partiality. He preferred Senate selection rather than the entire legislature because the entire legislature was larger and could give more room for such intrigue and partiality. Basically, the founders were clearly looking for a way to choose judges that would select qualified judges. The founding delegates considered many different appointment processes before settling on presidential appointment with advice and consent of the Senate, which was accepted without a single dissent. Larissa points out that some commentators focused on the fact that the delegates considered Senate appointment as evidence of an intention of an expanded senatorial role. But this doesn't make any sense. The founders rejected these ideas in preference for one where the president has the strongest role. Alexander Hamilton was the one who proposed a presidential nomination approved by the Senate. Another delegate, Mr. Gorham, borrowed from the Massachusetts Constitution for the advice and consent wording. He thought that even the Senate was, quote, too numerous and too little personally responsible to ensure a good choice. This went along with Madison's concern about legislators. Madison agreed with Senate approval of a presidential choice to prevent, quote, any incautious or corrupt nomination by the executive. Madison agreed to executive selection because the president would, quote, equally sympathize with every part of the United States, while the Senate might choose judges, quote, by a minority of the people. One founder, John Adams, was critical of the Appointments Clause because he was one of the founders who actually predicted the rise of political parties and feared the Senate would pass on nominees based on partisan reasoning. So, when we actually look at the discussion the founders had on the Appointment Clause, their primary purpose was to look for a process that avoided unqualified or corrupt judges. They rejected senatorial choice because they thought the Senate would be prone to choosing a suboptimal justice due to deal-making and because the Senate didn't represent the whole country like the president. They settled on giving the bulk of the power to the president, and some framers explicitly feared the Senate would go against the founders' designs and prevent appointments based on partisanship. Senators rejecting or ignoring nominees because they disagree with the nominee's judicial philosophy clearly goes against these designs. After the convention, Alexander Hamilton explained the purpose of the Senate's advice and consent role in Federalist No. 76. Quote, to what purpose then require the cooperation of the Senate? I answer that the necessity of their concurrence would have a powerful, though excellent check upon the spirit of favoritism in the president, and would tend greatly to prevent the appointment of unfit characters from state prejudice, from family connection, from personal attachment, or from a view to popularity. Did Hamilton say the purpose was for the Senate to have an equal say in who sits on the Supreme Court? No. Did Hamilton say the Senate's purpose was to reject nominees based on ideology? No. The purpose was to prevent people who were unfit for the job. The point was to stop the president from putting Cousin Clyde on the court, or some big political supporter. Hamilton said more, quote, but might not the president's nomination be overruled? I grant it might. Yet this could only be to make place for another nomination by himself. The Senate could not be tempted, by the preference they might feel to another, to reject the one proposed, because they would not assure themselves that the person they might wish would be subsequently nominated. It is not likely that their sanction would often be refused where there were not special and strong reasons for the refusal. Hamilton clearly did not see a strong role in the Senate choosing Supreme Court justices. Unfortunately, he was wrong about how the Senate would act. In the case of Merrick Garland, the Senate can like who the next appointment will be because they'll just refuse any of the president's nominations until a new president comes into office. This essentially usurps the president's power of appointment. In the Senate rejection of John Rutledge as Chief Justice in 1795, Hamilton, the guy who came up with the appointment clause idea, told senators to reject Rutledge only if they thought he was incompetent. Okay, thank you, Joseph Larissa Jr., for putting that history in one place for us. Now again, the Constitution does not ban senators from rejecting judicial nominees based on ideology or partisanship. The Senate can do this shit if it wants to, but to do so goes against the framers' intentions. Those delegates designed our democracy utilizing a system of checks and balances between our three branches. Part of the system they designed included the president selecting Supreme Court nominees and the Senate consenting based on the competency and integrity of the potential judge. This is not how the Senate has been acting. They ignore the founders' design and reject or ignore nominees based on ideological and partisan reasoning. Doing so steals power intended for the president and gives more of it to the Senate. And this could potentially lock up our system, as Senates can leave Supreme Court seats empty until they get their way, either by the president giving in or by a new president being elected. Our founders created a constitution that in many ways is vague. Often their intention is hard to determine. The framers disagreed on stuff. Much of the Constitution resulted from dirty compromises, and lots of the issues we face today are so different than what was going on at the time of this country's founding that the Founding Fathers' intention cannot be known. In such cases, we have to do our best to do what is in the spirit of the Constitution, as well as what will lead to a prosperous country. But the Senate's advice and consent duty is not one of these foggy issues. This involves a basic operation of our government's checks and balances system that is not affected by any amount of technology or culture or situational changes. The Senate often violates that intention, most recently by Republicans ignoring the nomination of Merrick Garland. Many of these, and their supporters, being so-called constitutional conservatives who say they care about the intent of the founders. Woe to the hypocrites. I'm Lone Candle. Like me, comment me, love me.